How many days in the Supreme Court are there?
We're actually only the one day. When you're in the Supreme Court, you only get an hour each, unless you've asked for more. And of course, as one of the judges has said, they don't make their decisions based on the arguments crafted by counsel in their hotel room the night before. They have clerks, and they will have looked at all of the materials that we have submitted, which are very substantial and cover this whole period going back to at least the Lenaine Commission in 72. So the clerks and the judges will have looked at all of the law and all of the other materials that have been filed. And the purpose of the oral argument is so that they can, we can make our oral submission, but they're there to ask us questions on the points that are bothering them. There's 9 judges who are likely to sit, and so we're there to answer the questions of the 9 judges and to try to do it within the hour that each of us will have allocated.
1 hour to change the world.
1 hour each or 3 hours?
Well, you know, as I say, all that other material, the written argument, the factums are all there, so you really, it's more than an hour in terms of the argument. But the oral presentation is essentially an hour each, subject to the court's questions.
Speaking of questions, are there any questions from the members of the press?
Do you think that the judges' decisions, like the decisions of politicians, will be swayed by American interests?
No, the court is an independent court that's governed by law and precedent. And so they're not subject to the whims of politicians. They don't make decisions based on political matters. Now, there's always a debate as to when is the court getting into policy and when is it into law. But again, they are the guardians of the Constitution. The politicians can come up with policy and try and translate it into law. But if the laws that they pass run afoul of the Constitution, it's the duty of the court to strike those laws down. Parliament can always try and get the formula right the second time around, but they have to meet these basic principles. And so the problem would be is that Parliament would have to construct a law that is consistent with the principles of fundamental justice, and the courts are there to ensure that that occurs. So
a recent example of them protecting scapegoats in Canada that have been persecuted in the States is the Brand decision, where they protected sexual orientation. And we're hopeful that they might even include substance orientation in their list of things to protect.
Well, the Friend case is an interesting case because, as David says, the court in that case precluded the Alberta government from preventing a gay man from working in a Catholic school, as I recall, with the basic facts. And so it was an example of where it was an emotional issue, and the Alberta government, I think, threatened to use the notwithstanding clause. And that's another section of the Constitution that the public needs to be aware of, because if there is some serious matter that Parliament thinks, or a provincial legislature thinks, warrants passing a law and saying that the Charter doesn't apply to that law, that's a very serious step. That's like the War Measures Act, that sort of thing. And they threatened it in relation to that legislation, but didn't follow through on it. So it shows that even though we're a constitutional democracy, and even though the court makes these decisions to protect our liberties and to protect these justice principles, at the end of the day, it's still up to the people. Because if Parliament decides to use that notwithstanding clause, usually the people don't like that. They don't like governments passing laws to which the Constitution doesn't apply, and the government takes its chances at the ballot box. And I think that's why Alberta decided not to use the notwithstanding clause. And there have been other governments and other issues that have risen in Canada where the government has been reticent to use that clause, even though the Reform Party or the Alliance has often encouraged them to do so. So, again, while the courts will strike things down and people think that that's interfering in the policy or legislative process, legislators can always reenact and try to get the formula right. And if they're really desperate, they can go to the notwithstanding clause and take their chances with the people.
They're going to lose in the court of public opinion. Because this drug war is over. Stick a fork in his butt. Turn it over. It's done. We've got the best facts. We've got more experts in the Lenaine Commission. We're living in the world, the age of information. We're going to We're going to have drug peace and drug freedom. They're going to let our people grow.
You should, I think, maybe remember that not only did the courts find the lack of serious risk of harm, they found that there were three vulnerable groups. Pregnant women, they said shouldn't smoke, the mentally ill, particularly paranoid schizophrenics, and immature youth. So, historically has occurred, not just in this country, there are different rules that are applied to youths and different rules for youths compared to adults. And so it's not as if there'll be no limitations whatsoever in relation to the consumption of this drug. You can anticipate that future legislation would still address those vulnerable groups and would still address issues of driving, operating complex machinery, or flying under the influence. Remember that those risks of harm were found by the court to exist in a black market context. And so when you take away the black market, when you have somebody who self-regulates, such as David did in the Harm Reduction Club, or if you had government regulation, those regulations or rules would serve to reduce the risk of harm. And so David, after he took the findings of fact in Caine and Malmo-Levine, in Caine, I keep referring to both because they've now been merged together, but he took the findings of fact in Caine, set up his Harm Reduction Club, put up signs and so on to dissuade immature youths, the mentally ill, or pregnant women from attending, had his members sign forms indicating that they would not drive under the influence, etc.
Not drive while impaired. There's a major difference between the two.
Yeah, no, I agree. So the law is that you're not to drive while your ability to do so is impaired by alcohol or drug. And I should add, for those people who worry about police officers being able to detect people in that condition, the police are very good at assessing whether somebody's under the influence of a particular subject, type of drug, and they can have them do roadside tests and so on to test their motor skills in relation to their ability to drive. And so the public shouldn't be concerned that suddenly there'll be all these marijuana smokers out there wreaking havoc on the highways. That's just not happened in the past, and it's not likely to happen in the future. So there are ways of reducing the black market risks of harm to below the trivial. And that's one of the points we also would hope to establish when looking at the issue of not just simple possession, but private use by an individual, but also looking at the question of somebody who's selling it to other people or distributing it to other people or perhaps growing it. Again, the question always is, are they posing a significant risk of harm to others that would warrant the government using the big stick of the law, the criminal law, to threaten people's liberty, to supposedly try and deter people from engaging in that conduct?
Some final thoughts. If marijuana becomes legal to sell and cultivate and use by next summer, there's some interesting things to observe. The price of marijuana would probably drop within 6 months to $35 an ounce, probably 1/5, 6, or 7th of its current cost, which will change the nature of the marijuana industry in this province irrevocably, as well as the rest of Canada. And also, once marijuana is legal, it will be possible, I would suspect, for thousands and thousands of Americans who face 5, 10, 15, 20 years in prison for commercial cultivation or any cultivation of marijuana, would likely be able to achieve, to some degree, successful refugee status here, because the difference between the two countries at that point would be enough to shock the conscience of the country. If something's legal in Canada, but people are getting 15, 20 years to life imprisonment in the United States, and it's quite likely thousands of them will flood up here, as well as they will probably receive a sympathetic hearing in comparison with the two agendas and the punishments meted out by the two governments.
Wouldn't you think, though, Mark, that while the price might go down in Canada, it's going to be somewhat like the old rum running days. The prices will remain maintained in the United States, and there'll still be a big market for the current growers and producers in the United States, just as there was during alcohol prohibition.
The only thing is that British Columbia is a vast, vast place, and I've checked this out, and if you use the economy of scale, we'd have vast greenhouses producing marijuana here. Amsterdam, where marijuana is basically legal, is the same price as Canada because it's a small little country and it's hard to grow marijuana in any quantity, but British Columbia is the size of California, Oregon, and Washington, and they can grow staggeringly large amounts of marijuana here. So the price will drop within 6 months to some shockingly low level because we'll be producing 10, 20, 50 times more marijuana.
I suppose we'll have coffee shops all along the
all along the
too,
border,
just
all
like
across
the
real
where I am in Abbotsford, the Sumas, Washington people used to make millions every time there was a beer strike because everybody used to go down to Sumas. So I suppose that the reverse will happen and they'll all be coming to Canada.
But the real money, I think, will be in breeding cannabis because not only will we be replacing a lot of the alcohol and tobacco use, which is a good thing, but I think the real money will be replacing pills. There's a $350 billion global industry in pushing pills on people, and the herbs are coming back. And cannabis is the #1 herb, and when people learn how to use it properly, and more importantly, breed it properly so you can get an antidepressant strain of cannabis or an anti-epileptic strain of cannabis or any of these other 100 uses for it, there'll be a lot of money in that, and I think that's where the chemists and the gardeners can work together to, they'll be both getting rich off the new medical potentials of cannabis.
Which raises the whole medical issue, and you'll maybe recall that recently Health Minister Anne McClellan was in the news hoping that the Supreme Court of Canada would resolve this issue of marijuana. And it was a bit ironic because this was after she had spoken to the doctors and said how she felt uncomfortable talking about smoking of marijuana when her ministry is trying to stop people from smoking. We have to remember that she was Minister of Justice at the time of the Parker case and made the decision not to appeal that case, but instead not to appeal it to the Supreme Court of Canada, but instead to come up with these new regulations. And so there isn't any appeal pending in the Supreme Court of Canada specifically on the medical issue. And just as an aside, you remember that Prairie Plant Systems got black market seeds that turned out to produce marijuana that was too good for their project, and too good in the sense it was much more powerful. And the irony of all that, of course, is that the more powerful it is, the less people smoke. They titrate their doses. And we know that the one problem from marijuana is not anything in the marijuana, but the smoking process. If you smoke the grass off your lawn, you're going to do damage to your large airways. So reducing smoking or alternative methods such as vaporizers and other ways of ingesting marijuana is certainly one of the focuses, particularly in the medical market.
Potency and organics.
If the Supreme Court of Canada does accept our argument and simple possession is decriminalized or legalized, or it's made so that Parliament can't use the criminal law to threaten people's liberty, then that will affect the medical market, because then people will be able to possess music for whatever purpose, medical or otherwise. And it's certainly my view that based on the evidence that I've heard in the medical cases, this is a drug that if you apply the usual tests for drugs, lethal dose ratios, therapeutic ratios, those sorts of things, it falls below the level where drugs would normally require to be prescribed. So you could use it like a natural health care product with or without consultation with your doctor, but having the doctor's approval wouldn't be required, and certainly having government approval wouldn't be required, which is currently the situation, and that's why these new regulations are being challenged.
Yeah, and I just wanted to remind everybody that all this hubbub, I've been fighting this for, I guess I've been waiting 7 years to get to the Supreme Court, and it's all just about a simple flower. It's quite beautiful, it smells nice. I remember the movie Saving Grace, where some of the people, or this, one woman just wanted to grow it because it smelled nice and looked pretty. I've got a little bit here, and it's a simple flower, and people have been, someone was just sentenced to 6 years in Nova Scotia for growing it and possessing it. A lot of people, especially in British Columbia, get off with light sentences, but there's still people going to jail in Canada. So many tens of thousands of people getting criminal records for simple possession of what's no more than a flower.